Going. All right. So we are here today to talk about the buyer pre-closing occupancy addendum. My name is Nicholas Peasley. I'm one of the staff attorneys at Oregon Realtors. I had a hand in drafting the forms. That's why I'm doing a handful of the presentations on the forms. So we're going to talk about buyer pre-closing occupancy addendums today. If you were here last week, Jeremy talked about the seller post-closing occupancy addendum. This is for the corollary, the opposite situation where the possession date is well before closing as opposed to possession being well after closing. So these are ill-advised transactions, but they happen, and so the form needs to be there for when these do happen in these kind of fringe scenarios. So the form itself is 2.17 in the library. It is called the Buyer Pre-Closing Occupancy Addendum. It is an addendum to the purchase and sale agreement. In theory, it's also a standalone separate agreement in its own right because there is, to a certain extent, an exchange of consideration that goes on with this transaction. So this will happen every once in a while when you have a buyer that moves into the property before the closing date, a buyer that's moving in from across the country and can only get the plane tickets for like a week before the closing date or something along those lines. It happens. It's not common, but it happens. In those instances, the buyer will generally either live in a motel, a hotel, or in some cases, they'll just move into the house. And the seller and the buyer will have some kind of an agreement that exists, an occupancy agreement that allows the buyer to remain in that property before the closing date, until the closing date, or until a specific date. We'll cover it. In this training, we're going to go over pretty much every provision in the occupancy addendum. We'll cover them one at a time, or in some cases two at a time, but it'll be broken down in what we're hoping is a reasonable and understandable way. These occupancy agreements are the way that we ensure that there are termination, eviction, payment terms, and all of kind of the general things you need in a lease agreement. If you don't have an occupancy agreement, you won't have those terms. We'll get to that a little later on, but it's a fringe area of Oregon law where just because you live in a place doesn't mean you're technically a residential tenant under Oregon law. So the way this begins is this is section 7 from the actual purchase and sale agreements. This is form 1.1, section 7. You have a closing date and then a possession date. It says if the possession date is different, you'd write in the possession date. So if you're closing on, what day is today? March 9th, March 12th, or May 12th, I'm sorry, I'm way off. May 12th at 5 p.m. May 12th at 5 p.m. we go in on a closing date. If the closing date and the possession date are the same, you don't need to write anything in the possession date section. You can if you want to. May 12th at 5 p.m. Wonderful. Now you have a closing and a possession date. They're the exact same. If, on the other hand, you have a closing date that's May 30th, but the possession date is May 12th at 5 p.m. That means that you have a buyer who is moving into the property because they're taking possession well before the actual close of the transaction. The closing date is when you close the transaction, record the documents, and shift the ownership of the deed off to the new buyer. The possession date is when the buyer moves in and gets to actually take up occupancy, quiet enjoyment, and all that other stuff. This is specifically the area that we have on this is the closing date and possession date. If you put in a possession date that is after the closing date, you're going to use form 2.16. That's the seller post-closing occupancy. The seller is being a tenant in their own house afterwards. If the possession date is well before the closing date, buyer pre-closing occupancy addendum, form 2.17. That's our little nomenclature there. In theory, we could have put much more description in that little parentheses, but just for your information, if the closing date is well after the possession date, that means that the buyer is moving in before they close. You're using this form. That's hopefully a straightforward thing. I imagine there will be questions about it over time as these forms get used more and more. These fringe scenarios do pop up, so you might need the form. The actual form itself, this is section 3 of the form, 2.17, section 3. It describes the usage case of the form. It specifically says that this agreement is not subject to Oregon Residential Landlord Tenant Act. If you are a property manager or if you've worked with property management in the past, ORS 90 is the Residential Landlord Tenant Act. It is kind of the bread and butter of all the way that we deal with Oregon tenants and landlords and residential tenancies and leases and all those things. It has all the eviction terms, all the termination stuff, all the stuff about relocation. Everything that dictates the lives of a property manager is in ORS 90, more or less. And when you have a transaction that is less than 90 days long, you don't apply ORS 90. It's weird, it's odd. There's no real great answer for why the legislature decided 90 days is the number, but that's the answer. That's what it is. You can see on this little section down here below, this is ORS 90.110, which explains that there are exclusions from the Residential Landlord Tenant Act. Specifically, if the person is occupying a dwelling unit for no more than 90 days, If that's the purchaser or if it's the seller following the closing of the sale, they're living in there for less than 90 days, ORS 90 doesn't apply. Which means in theory that all of those, like, you need to give them 90-day notice to terminate and all that other stuff, that doesn't apply. It doesn't exist in these transactions because the law specifically puts it outside that category. Now, that might sound like a great thing and it might sound like a terrifying thing. It's kind of both at once. What this means is if you are a seller and you have a buyer moving in, you need to put all of the eviction terms, all the ways that you get your payment, all of the terminology, all the contracting for what would normally be a lease. You have to do it intentionally between the parties because there's no safety net of ORS 90 that will do it for you if you don't. That means if you say, hey, buyer, you can live in my house for the next 85 days, but you don't give a termination right in that agreement, theoretically, you can't terminate the buyer unless you're using common law standards, which means you're going to have to hire an attorney and they're going to have to do a lot of research to figure out how to terminate what amounts to an agreement that doesn't exist in writing. So it's very expensive if you don't have one of these occupancy agreements if something goes wrong. It's the safety net that you would normally get from ORS 90. It's just written into the contract itself. If you have a party that wants to live there for more than 90 days, if the buyer wants to move in for 100 days, 120 days, whatever it ends up being, you need a lease because ORS 90 applies. At that point, 90 days is kind of the razor's edge, the sword point that decides whether you are a residential landlord-tenant situation or one of these weird occupancy agreement situations. If you are doing something for like exactly 90 days, you still probably want to lease in that instance because if the buyer stays for 1 day beyond, now they're a residential landlord-tenant act situation. So this does apply to those holdover situations as well. So if the buyer is occupying the dwelling for more than 90 days, even if the agreement only said you can stay here for 90 days, if on the last day the buyer's like, yeah, I'll get my stuff out in the morning, you're at 91 days now, which means you have to give them notice to get them out of that house. Which is troubling and problematic, and it means that basically don't let someone stay for more than 90 days. On the 90th day, they need to be out. Do not harbor any differences on that unless you have a lease in place. The agreement itself, this is section 4. This is a lion's share of what you're going to be dealing with in these pre-closing occupancy addendums. It's kind of all the terms and timeframes for stuff. So in this section, we'll kind of point out the areas that start out. We begin with this first part, occupancy. The seller grants the buyer the right to occupy the entire property, or maybe just part of the property, and you would describe it. It can be a component of the property. It can be a single room. It can be the garage. I'm going to walk that one back, actually. If the buyer is living in the garage and it's not a permitted building that's a dwelling, that's bad. Don't do that. So the buyer can occupy a portion of the property, but if they're going to be dwelling there, it has to be a dwelling. In theory, these pre-occupancy addendums can also be used for not just like living in the space. If the buyer's moving their junk into the house and they say, hey, I want to be able to use the garage, you can sign a pre-closing occupancy addendum that says, okay, buyer, your stuff in the garage, you can use the garage, seller won't be using it. And that can be done through describing the portion of the property. That gets a little more kind of finicky, and you might want some additional addendums that specialize into that unique information that you're dealing with. But in general, this should be for occupancy or dwelling in the space. So if the buyer is moving in and they plan to rest their head somewhere and cook their food somewhere in this house, specify what part of the house they can use. If you're going to be letting them live in one room, but they can also use common areas, you need to define those in this section here. You need to define the common areas. That means if the buyer just uses a bedroom, they just have a bedroom. If the buyer gets to use the bedroom, the hallway, the kitchenette, the bathroom, describe those spaces that the buyer is able to use. If they're sharing occupancy with the seller, you're going to describe the shared ownership in this section. More likely than not, our hope is that if you're going to be filling this out, in most cases, you're just going to do the entire property. It's the easiest scenario. If you're doing something more granular than the whole property, be very detailed, very specific about exactly the rights that the buyer has in those various spaces. If the seller doesn't want the buyer wandering into the crawl space while they live in this property, then don't let the crawl space be one of the spaces that the buyer is allowed to use. That's not a portion of the property they get to be in. Theoretically, in this section as well, if you're describing a portion of the property, you can also describe it by exclusion. Say a buyer is allowed to occupy all of the property except for the ADU or except for the upstairs part. Whatever it ends up being, you can do a full reference to the property and then say except for or but for these pieces, and you can make that reference as well. You're going to also specify the exact beginning time of the arrangement and the exact end time of the arrangement. The occupancy begins at, and you can choose a time specifically. If this isn't filled in, it's going to be 5 p.m. And then on a specific date. If you don't write in a date, that's a problem, and that's not good. So you need to fill in a date. There's no fill in on that. So this first part can be left blank. This second part, do not leave it blank. You need to fill that in, and you would choose to begin it either a certain day on a certain time, or it can be a certain time, a certain number of days before closing. This second one is for the people that don't want to do math. You could always just pull up Google and say what is 85 days before April 3rd, and it'll tell you. But if you don't want to deal with that, you can always say blank a clock at blank number of days before closing. That would be the closing date that is written into the purchase and sale agreement. It's a defined term in the purchase and sale agreement. That doesn't mean if you put what it does in theory mean as well is if you put an extension on the closing date, that does kind of monkey with those numbers, and it's not exceptional. If you have to pick a default, the first box is always the one we would want you to choose. Put a very specific date in for when it starts. If occupancy is going to end, you want it to end on either a very specific date or at closing. This can happen. These are weird situations where a buyer moves in. They've got like a 90-day closing. They move into the house for 60 days, and then they're on vacation for 30 days, and they don't want to keep renting the house. So they occupy the property for 60 days, and then they're done occupying, and then closing happens. It shouldn't happen often. More often than not, the second box is what you should be picking, which is buyer, your occupancy is over on closing day. Once you close, the occupancy is over, but the buyer is now the owner of the property, which means they don't have to move their stuff out by 5 p.m. on the closing day, because at closing, now the buyer owns it. There's no reason to have the buyer, move all their stuff onto the curb only to move it in again once they've signed the escrow documents. So it is what it is, but specify. More specificity is always preferred. The beginning time, put a specific date if possible. The closing time, put the closing date or the specific day that you're planning on having it close. If you are worried about that 90-day kind of overload situation where the buyer is staying on beyond 90 days, specify the date and make sure that you put it in at a very specific time. So if you do extend closing out, if you say, buyer, you can move in tomorrow on May 13th, buyer gets to move into the house at 5 p.m. Lovely. Closing is when we're going to be done with this. If you have extended your closing date and it's more than 90 days, you need a lease in place because the buyer's been occupying that house for more than 90 days. So be cautious if you put a specific beginning date and a broad or expansive closing date. It's always preferable in these leases that you put a specific begin date and a specific end date, and that specific end date would be miraculously the day of closing. But it then ensures that you don't have that situation where the buyer can say, well, I get to stay here till closing. We haven't closed yet, so I'm still here, and it's been 120 days, so now you have to give me 90 days notice before you evict me out of the property or something along those lines. So be aware. There's also the statement in this one that says the buyer's right to occupy the property will automatically terminate at the end of the terms described above or at the end of 90 calendar days, whichever is sooner. So we do put in kind of a safety net that says, hey, buyer, your occupancy is over after 90 days. Now, with that said, if the buyer is there beyond 90 days, that's when the Oregon Residential Landlord-Tenant Act applies, and you do need that lease in place. So even though the lease says that they're terminated, someone can stay on the property beyond that and be considered what's called a holdover tenant at common law, and that becomes a really kind of problematic statement. So even though we do advise that you set it up as a very distinct time front lines and dates, we also have a safety net here. With all those safety nets in place, tenant can still go to a court in Oregon and argue I am a tenant, and sometimes the court will agree with them. Because of that kind of confusion of the law, we're trying to put in as many extra savings in here that can make it stronger for the seller to say, I don't have a tenant. You were supposed to be out on the 90th day. The lease said so. The lease said so twice. It said also on the 90th day you're done. All of those things in place are supposed to protect the seller in this case. If the parties do terminate the sales agreement, so if you do for whatever reason have an agreement that falls apart while the buyer is living on the property and you can't agree on some day to terminate the occupancy, the buyer gets 15 days from the day of that termination. So seller and buyer terminate for whatever reason. The inspection turned out to be bad. The buyer didn't like the inspection and they say, I don't want to live in this house, or I don't want to buy this house, but I'm still living here. If they can't agree on when the buyer is out of that property, the buyer's supposed to be out 15 calendar days from then. So 2 weeks plus a day is, we set it up as calendar days because leases kind of operate on a weird scale. 15 days felt like a reasonable amount of time. The parties could in theory change this with a general addendum, but 15 days is the amount of time we've set as a pretty okay, reasonable amount of time for a buyer to get out if they have terminated the contract. Our hope is that the parties will not terminate the contract because that creates real problems. This occupancy, this 15 days after termination, will not extend the time that the buyer gets to stay in the property beyond the 90th calendar day. The way to think about it is it's sort of like the 90 calendar days is a point in time that just it's an automatic stop. So if you're on day 85 of your lease and then for whatever reason your sales agreement terminates, the seller would send the buyer a notice that says, hey, you got to be out of here within 15 days. And then on day 90, the seller would say, it's day 90, you need to be out of here, which in theory means you have two simultaneously moving notices of termination, which you can do. It's a stronger way for the seller to terminate at that point. So if you do have one of these early termination, the sales agreement falls apart, and that 15-day move-out period takes the buyer beyond the 90th day, be aware, buyer is supposed to be out on day 90 because we're not doing a residential landlord-tenant act situation. We don't want to deal with that at all. The buyer is supposed to specify exactly the right that they are taking to the property. They have a right to occupy the property that is exclusive. What that means is they're not like sharing a bunk bed with the seller. And for residential uses of the buyer, in theory, in a general addendum, you can modify that into storage uses, or you can modify that into various other uses. If the buyer needs to use the space to park a car or something, you can say those. And then you need to specify how many additional people and how many pets are supposed to be on the property. Be aware you need to specify those things very distinctly. However, because fair housing law applies, if the buyer does send the seller some sort of a notice that says, hey, I've got an emotional support animal, a service animal, whatever it ends up being, the seller has to allow that emotional support or whatever it is animal onto the property, even though the lease or this occupancy agreement might not say how many pets there were. It's a problem that a lot of property managers run into every once in a while, where they'll say, well, the lease only said you got one dog, and now they say I have two emotional support animals and my psychiatrist says I need them. Well, I only allowed you to have one. You can say that as a landlord, but it's a really, really fraught lawsuit, and we don't advise that. The easiest approach is just to say, look, if they're asking for the support animal and they have documentation from the medical provider, don't blockade that, because you don't want a fair housing lawsuit as a landlord, especially on one of these ones, because these are serious lawsuits, and the property manager can get in big trouble as well. So if you're the broker that is telling the seller, oh yeah, you don't have to let that dog on the property, you already let them have one dog, now they don't need a second one, they don't need that. You can get in big trouble, and it can be significant fines from the like federal level. You can read about those on HUD's website. There are all kinds of lawsuits that happen when people deny service animals. So even though you're specifying how many animals there are fringe cases where the buyer can still kind of force another animal into the property. Otherwise, if the buyer says 0 pets, they don't get any pets on the property. The buyer can't say like 1 pet and then bring in 2 small dogs and say, well, they're just the same size as 1 big dog. Doesn't work that way. They should specify how many pets there are. Pets are a particularly special area because they are what amounts to a strict liability problem. If you have a dog on the property and it bites someone, it is your fault, even though there are signs that say beware of dog and dog is dangerous, all kinds of stuff. If your dog bites someone, you are guilty as long as they can prove you own the dog and the dog bit them. So pets are a really significant problem when it comes to rentals in particular, because the seller is technically the owner of the property, and that means there's a lawsuit that can happen. For that reason, the seller needs to have their eyes wide open as to how many pets they're dealing with on this property. Be aware there's also the right to sublet. The buyer is technically not, as a baseline, buyer cannot sublet. However, you can put an exception in there. You can say, well, okay, buyer, you can sublet for the first week of the occupancy term, or you can sublet to your cousin or something like that. So you can put exceptions in, but the baseline is subletting is not allowed unless you say otherwise. So that's these are the base terms. Say how much of the property they get to rent, say when they start, say when they end. Be aware there's an end, like a drop dead date on the lease. Say how many people, how many pets, and say whether or not they can sublet. Be aware on that people, additional persons, this is spouses, children, and all that other stuff. If they have a baby, that is 1 additional person. And this isn't going to change much else. It's just telling the seller how many people are actually moving in. If the buyer just wanders in suddenly with like 30 other people, and their cousin and their friends are all living in the property, that's troubling. Let the buyer do that after they bought the house, not before they bought it. Section 5 is all of the payment terms. This is the way that we kind of figure out how much the parties owe. The 2 options in this case are either a total amount or an amount of blank per day for a total amount of blank. That total amount per day is for those kind of more flexible ones where it's like we're basing this on closing date, and closing date is a little uncertain. It could move a bit. You can put a per day in amount and then modify that total amount as things change. In general, the buyer is going to be paying this through escrow and it'll be distributed to the seller at closing, which means the buyer, if this, let's say you said total amount of $3,000 and the buyer has not put a general addendum in that changes these terms, the buyer is going to give escrow $3,000 and at closing the seller gets the $3,000 as well as the purchase price. It's a separate amount of money that is not connected to the purchase price. So the buyer spending $3,000 to live in the property under the occupancy terms doesn't get to subtract $3,000 from the purchase price. It doesn't work that way. That's not how it's supposed to work at all. So if there is a failure of the contract or some kind of thing, escrow is going to generally decide how that money goes out to the seller. Usually this involves identical instructions from the buyer and the seller. That's how it's supposed to work. You can put in the general addendum and agree to other things where the buyer pays seller directly and they pay every week or something along those lines. You can do that, but we're just farming it out to a general addendum. The reason why we didn't put check boxes in here for that is there are an infinite number of ways that you can set up payment terms under something like this, and we just didn't want to have to like trawl for every possible way, pay daily, pay monthly, pay weekly, pay every other week, pay at 5 p.m. in a Dropbox, pay on a PO box, all those other things. Just put it in your general addendum. If you're going to do something different than paying through escrow, general addendum. The security deposit is section 6. This is not required, but it is there just in case. The security deposit, your options are you don't have a security deposit, there's a $1,000 security deposit, or there's a blank dollar security deposit. This security deposit is designed to basically follow through with all the other reasons why you'd use it. It follows all other laws for how you use a security deposit, which means you're going to be using it to cover repairs, you're going to be using it to cover unpaid rent, that kind of thing. And if there's no problem at the end of the transaction, the seller refunds the security deposit to the buyer. If the buyer breaches a term of the contract, then we'll get to it, but there are ways that the seller can recover elements of that security deposit. This is designed to be a protection for the seller. If you don't have a security deposit and while the buyer is living there, they kick a hole in the drywall and then the buyer terminates the transaction, there are bad people in the world. They do these things. At that point, you want the security deposit because you can put that money, forward that money into basically paying for the repair of the drywall. The deposit doesn't need to be in a trust account. That's a weird thing. If you're a property manager, that should send up your little antennas and say something's wrong. The reason why that's the case is ORLTA does not apply the Oregon Residential Landlord Tenant Act. That's the thing that normally says got to be in a trust account. It's a security deposit, but it's not like a real security deposit. It's an occupancy agreement kind of shadow of a security deposit understanding here. The buyer must provide an address for where they live. This is one of the other elements of this. Buyer must provide seller with buyer's contact information for returning the security deposit and for maintaining contact during the occupancy term. Now, that might sound silly because the buyer is living in the property. What this usually means is it can be something like a PO box. If the buyer gives the seller the property address where the seller owns the house and then the buyer terminates and moves out, the seller hopefully will be able to find a property address they can send the security deposit to, but the buyer should give them something that can contact them. So a former address, a current address, an address of a family member that can get the contact information to them. A PO box is preferable in most cases. Some way to contact the buyer, because this is how the seller is going to send the security deposit back to the buyer, is with that address. If there is a termination, refund the money, or if the contract closes, if you sell the house to the buyer, at that point, refund the security deposit. This is the continuation of this section 6 part. If the buyer has breached a material part of the contract, the occupancy agreement, the seller can retain a portion of the security deposit necessary to cover the damages suffered by sellers, or any of the reasonable costs incurred to repair or expected to be incurred from the buyer's breach. So in that instance where the buyer kicks a hole in the wall, seller, you can retain as much of that security deposit as reasonably would go into repairing it. That doesn't mean that you're going to use they kicked a hole in the drywall. That's a $3,000 job. No, doesn't work that way. That's unreasonable. That usually means the seller should provide some sort of an accounting that says, hey, buyer, this is how I spent the money. This is how much money the contractor is charging per hour. It took 1 hour to fix the drywall. When the seller does retain a portion of the security deposit within a set number of days, you can decide this. It can be 10 business days is a nice default, but it might be more if you need it. After the money is retained, during that time frame, the seller is supposed to provide buyer with the written explanation of the breach and the damages suffered. Hey, buyer, you kicked a hole in the drywall. There's a gaping hole in the drywall. I can literally see the electrical lines, the coaxial cable and all that stuff. It's visible. That's a problem. You would describe it. You would say this was here's a picture of the drywall hole. You would have an itemized list of the repairs. I had to hire a contractor. He had to buy drywall. He had to buy that weird like mesh tape to put on the wall. He had to buy this backly stuff. He had to buy white paint, and he made the whole job happen. It looks lovely. Here's the estimates or receipts from that contractor, and here's what's left in your security deposit. So you would give the buyer this written accounting that basically says, in the security deposit, there was this much money, you caused X amount of damage, here are receipts that show that the damage cost X amount of money to fix, and therefore there is $0 left in your security deposit, something along those lines. There is also the buyer obligations. So this is an important element of these contracts. Essentially, these are the things the buyer is supposed to do while they live in the property. Note, the buyer is supposed to comply with all laws, covenants, conditions, and restrictions that are related to the property and shall not interfere with the legal rights held by others. What this means is if you have CC&Rs, if there's a homeowners association that says, you can't park a car in the driveway during these and such hours of the day, the buyer is supposed to adhere to those. They're supposed to follow those rules. In municipalities, for example, sometimes chickens are banned. If the buyer moves in with their 2 chickens and a rooster, that's a problem. The buyer's not supposed to do that. And so the buyer should be following the law. Even though they're a tenant, they still are supposed to follow the law, which is reasonable, and that's what we're kind of generally hoping they do. Buyer's not supposed to follow or do any unlawful activities on or about the property and should not interfere with the peaceful enjoyment of other people's properties. If you're a buyer, don't set the house on fire. Don't set off fireworks in the backyard generally. That's not okay. I suppose on the 4th of July it might be okay, but that's within reason. If you're a buyer, you shouldn't be like cooking meth on the property or something. That's a problem. Don't do that. There's all sorts of reasons why that would be a problem, but basically what we're saying is, buyer, don't mess up and don't mess up other people's time while you're here. This is a privilege. It's not a gift. The buyer should not store dangerous products that could cause damage to the property or increase the likelihood of a property casualty. That it might sound silly, but there is all kinds of case law about buyers that store like truly toxic chemicals or like dynamite on the property and they blow up the garage. So be aware, if you're a buyer, don't move your dynamite in until you own the house. It's more of an old west understanding, but in the modern era there's all kinds of stuff like that. Some of these ideas of like a dangerous activity or a dangerous product, you can look to federal law. There are a fair number of ways where dangerous substances are defined. It's not always as simple as like is it toxic to human health? Because sugar is to a certain extent. If you eat enough of it, they're very well defined categories under federal law for what a hazardous subject is, as well, or a hazardous substance is. You can even look to Oregon law on hazardous substances. There are quite a few, and usually any of those lists at a federal or state level are acceptable as things to basically say, buyer, don't do this. Don't bring your civil or your World War II era mustard gas container with you because that's dangerous. It's not cool. The buyer should not make any improvements or alterations to the property without express consent of the seller. Please, buyers, don't do that. While you're living on the property, it still belongs to the seller, which means you can't change it. You can't fix it. You're not supposed to be turning it into an open concept kitchen while you're living there. Wait until after you own the house to make those changes. You can ask the seller, and if the seller says go for it, then great. But don't do it without seller permission. If you are a broker that's working with sellers and the buyer does ask permission to do something sketchy on the property or to do an improvement on the property that they're maybe not qualified for, get it in writing. Make it really clear that the seller wants in writing a statement from the buyer that says, hey, I want to do the following thing. Do I have your permission to do it? That way the buyer can't say afterwards, like, what are you talking about? There was a problem. And you'll have a written proof that the buyer has been the one making those changes and that the seller approved the buyer doing that. So have it in writing. The buyer shall keep the property free and clear of liens caused by the buyer's actions and shall indemnify the seller for the same and pay all reasonable costs and attorney fees associated with removal of said liens. If the buyer is living in the property, they shouldn't have gambling debts assigned to the property. They don't own it yet. That happens. Sometimes you'll have something where a buyer is living on the property and then the judgment lien gets applied to the property because the lien creditor basically says, I don't know what this buyer has, but I see they live in this place. That's what their address is on the court filing. So I'm going to then put a lien on this property because the buyer lives there. The seller, if they suddenly see a lien that's applied because the buyer is living there and it's due to the buyer's actions or the buyer's inactions or misdeeds, the buyer will pay that off. They've agreed to under this lease. If the buyer doesn't, then theoretically the seller gets to terminate or otherwise keep the security deposit. It's usually not enough to cover the lien, but the seller is also protected from that lien because they can say it's not me that caused this. So, but the long story behind this is buyers don't put liens on houses. Don't get a second mortgage on the house you don't own it yet. That sort of thing. And you'll also indemnify the seller for all the problems you cause. While the buyer is living there, they are in charge of upkeeping the smoke and carbon monoxide detectors. That's a special little writing that we put in on this one. It's a contractual agreement between the parties. If the buyer does not upkeep the smoke and carbon monoxide detectors, the seller is still technically supposed to make sure that's the case at closing. Otherwise, the seller can get fined under Oregon law. This is one of those buyer obligations, and we would ask that the buyer does it. If the buyer doesn't do it, the seller can say, "Buyer, you didn't maintain the smoke detectors. I have to replace 2 or 3 of these smoke detectors. Otherwise, we're out of compliance." The seller can then charge against the security deposit and say, "Buyer, I have to buy 3 smoke alarms because you didn't upkeep them. They all died while on your watch, or I have to buy batteries to make sure they all work. We're taking this out of your security deposit to pay for the $25 in whatever those esoteric expensive batteries are that go into smoke detectors." Section 8 is information about the property condition at the time of possession. So this one is the idea behind the responsibilities that both parties share as to the property itself. We'll point out this first chunk here. The terms of any cleaning provision in the underlying sales agreement only apply if the occupancy term ends more than 10 days before closing. If the cleaning provision does not apply, the buyer agrees to accept the condition of the property as is, where is at closing, regardless of any damage to the property that occurred during buyer's occupancy. So the sales agreement has a provision in it that says at closing, seller will provide a clean house to the buyer. They'll make sure the house is clean. We've even had people request the phrase broom clean. That cleaning provision doesn't apply if the buyer lives there up to 10 days before closing. So if the buyer moves out, their occupancy ends the day before closing, we're not going to force the seller to go in and sweep all the refuse from the buyer's occupancy out of the house. The seller doesn't have to. If the seller has 10 business days to clean it up, then yeah, seller, make the house clean. But if the seller has less than that, we're just saying, buyer, you track the dirt in, it's now your house with the dirt. That's, you caused it. If the buyer's a dirt grub, then that's on the buyer to live in a dirty house. The seller doesn't have the obligation to clean that mess up. The buyer is therefore accepting the property with all of its messes that the buyer has caused. During the occupancy term, the seller's duty to repair or replace any system or appliance becomes inoperative. When it becomes inoperative or malfunctions, it doesn't apply. So there are some exceptions. This is what we state out here. It's essentially if it's necessary for the home warranty, if the damage is caused that was caused to this appliance or this system is covered by a home warranty or by insurance, or if the seller caused the damage, the seller will repair it. Otherwise, it's on the buyer. So if while the buyer is living there, the buyer loads 20 towels into the washing machine and it causes all the little rubber straps to snap, the seller doesn't have to fix that washing machine because the buyer broke it. That's the buyer's fault. The seller doesn't have to fix that. If the buyer's living there and they use the stove and they leave it unclean for the next 10 days or something and the stove burns out, that's the buyer's fault. If the seller has a warranty that covers that, or if the insurance will cover the replacement, sure, seller, go for it. But if it doesn't get covered by that, it's on the buyer. It's the buyer's fault that it fell apart. It's on the buyer. Now, if the seller caused the failure of that thing, let's say the seller goes in one day and is talking to the buyer and you're like, yeah, check out how cool his washing machine is. And they put, I don't know, like a brick in the washing machine or in the dryer, like that one fun video on the internet from years ago. That's the seller's fault. They got to replace that thing with a like quality appliance. So basically, this just limits and shrinks down the replacement value or the replacement obligations of a seller under the rights of the sales agreement. It says while the buyer's living here, the same replacement rights don't apply. I'll go back a step. You should also note buyer and seller should carefully review the sales agreement. Buyer understands that unless otherwise agreed in writing or listed as an exception in this paragraph, the buyer is responsible for the repair and replacement of any systems, components, or appliances that fail during their occupancy. So buyer, if you're in the house and during the time you're in the house because of usage, you caused the garage door to fall apart. You caused the garage door to fall apart while living there. The seller is not going to replace that unless it's covered by the warranty or the insurance or those other things. The seller doesn't have the obligation to put in that other quality garage door with a couple of days worth of usage left in it. That's not going to be there anymore. So buyer, once you're living there, it's on you for all these things that you're going to be using or breaking. Seller's remedies and eviction. This is section 9. So this is usually the important section that sellers really want to know about. What are your eviction rights? What can you do if the buyer is in breach? If the buyer is doing untoward or naughty things, what can the seller do? So if the buyer fails to vacate the property at the end of the occupancy term or otherwise is in default under the occupancy, seller can file an eviction action with the court. This is ORS 105, 105 through 105, 168. These are all of the forcible eviction detainer actions. They're clunky. Be aware if you're going to be evicting someone, you should probably get an attorney. You don't really want to do that thing just kind of on your own. It's a complicated process, and you don't want to mess it up. The buyer in this case needs to give at least 24 hours written notice of the termination of this occupancy. So if the buyer is going to boot this seller, or the seller is going to boot this buyer out of the property, you need to give them 24 hours notice. This comes directly from ORS 91.130, which requires that the tenant get notice before the termination, but only needs 24 hours notice. Giving this notice does not make the seller a landlord under ORLTA, the ORS 90. So you can send this kind of a notice of a forcible eviction detainer process without becoming a landlord. That's why it's still encouraged here. If this was something where by sending notice you became a landlord, we'd have a whole different problem, a whole different process here. So 24-hour notice if the buyer fails to vacate or is otherwise in default under the agreement. Buyer will be liable to seller for twice the actual damages suffered by seller as a result of buyer's failure to vacate, or plus the reasonable attorney fees, costs, and expenses incurred in pursuing the eviction. The expenses to seller are negligible in most cases. It's very difficult as a seller to argue that a buyer staying in the property for like 2 or 3 days causes you huge damage. That's kind of, I see a question in the Q&A. If HVAC quits working, is it the buyer's responsibility to fix? If the HVAC quit working during the occupancy term and the seller's home warranty or seller's insurance doesn't cover that, in that instance, we would say it's the buyer's responsibility to fix it. The reasoning behind why that's the case is essentially under the lease that would the buyer is living there and they're the one using it. If the buyer owned the property, they would be the one replacing it. The right or the obligation of fixing it would be on the buyer. In this instance, because the seller is not a landlord while technically allowing them to use the space, we're kind of shifting the blame on this thing. We're shifting the obligation. Under the sales agreements, the seller is only required to fix a thing up to the quality it was when the offer was entered into. So even if the HVAC system quit working in a normal context when the buyer wasn't living in there, the seller would only have to put in one of kind of like quality, which is just a patch over until the close of the transaction. So if I have an HVAC that has 10 days worth of life in it, in theory, I only need to repair it to a point where it has 10 days worth of life left in it. That's what I need to repair it to so that when the buyer buys the house, they get exactly what they put their deal on. That's not how most people operate because that's kind of, it's a slimy way of doing things, but like that's the law and lawyers are the ones that created that. So the way that we've established it under these agreements is buyer, it's on you. If systems fail to work while you're living there, you are supposed to fix it, buyer. And the level of fix that the buyer needs to do in theory only goes up to the amount of whatever the property, the quality of the thing was at the time that they took occupancy. So if the buyer took occupancy and the HVAC system only had 10 days worth of life in it, the buyer needs to fix it up to 10 days worth of life fixing. So like, replace it with a pretty old battery. And then if the agreement terminates or falls apart for whatever reason, the seller gets it back with the 10 days worth of life that they would have had otherwise. Generally speaking, though, the responsibility is on the party living in the property to fix that thing. The reason why we can do this without creating huge problems with the actual ownership rights of the property is this is not under the Residential Landlord Tenant Act. So the maintenance requirements are not the same under these kind of leases and these kind of arrangements. And by contract, we've essentially forced the right of repair onto the obligation of repair onto the buyer. So where were we? Liability for damages suffered. When a buyer fails to vacate, you don't usually have damages. What the real meat and butter of this is for reasonable attorney fees, costs, and expenses incurred in pursuing the eviction. It can get relatively expensive to evict someone, a couple $1,000s to get an attorney to do all the documents properly and to go to court and do the filings and all that. The buyer is going to be paying for that. All of those costs the buyer will pay for at the trial, appeal, or mediation. So the buyer gets or the seller gets that money back if they have to go through this whole rigmarole. The seller can pursue a right to eviction under this section, and it won't create the landlord-tenant relationship. We talked about that. All the remedies other than eviction that will be pursued in the dispute resolution are still allowed. So under the sales agreement, if there's a breach of various other contract terms, you can go through a mediation, arbitration, small claims court process. You can still do those things. This is a separate pathway. It's basically there are two streets that you can go down for these kind of disputes. There's a dispute for, hey, buyer, you caused damage to the property and you won't move out, so I'm going to sue you to get you out, while also coming after you for the earnest money because you're a mediocre buyer and you caused damage to me during the process. That's the idea in this, is that the seller can come after either of those. They can do the mediation arbitration process while also pursuing the forcible eviction detainer on the opposite side. Curable default under the sales agreement is one that needs a opportunity or of default, a notice of default and opportunity cure. So the idea in this case is that in the sales agreement you would normally need to send a notice of default and opportunity to cure. Under this one, the notice of default is not required. So defaults under the occupancy agreement don't need this specialized notice of default form. They're just, you defaulted on your lease, now we have a problem and I'm going to pursue potentially causes of action against. Section 10, early vacancy. What happens if the buyer moves out before they're supposed to move out? Buyer says they're going to live there for 40 days. Buyer's only been there for 10, and they say, yeah, I don't want to live here anymore, and they move out. What are we supposed to do? The buyer needs to provide the seller with 24 hours notice before they move out early. If the buyer does intend to vacate the property, they can do so. Unless the parties agree in writing, the buyer is still obligated under this agreement for the entire occupancy term and the cost of that term. So just because the buyer moves out doesn't mean the buyer is off the hook for all of these various rights and obligations. They still technically have paid the seller for the lease term, and they're supposed to be able to, like, they should still be paying that. The idea behind this provision in large part is if the seller has vacated the space so that the buyer can live there for 40 days and the seller has made arrangements to live elsewhere for the next 40 days, the buyer suddenly moving out doesn't undo the expenses caused to the seller. And so in that instance, the buyer, you're still paying all the things that you're supposed to. The parties can agree to refund it. If the seller just wants to move back in and they say, we'll refund you on a per diem amount, that's fine. You can do those things, but you don't have to. Seller does have a right to access at reasonable times with reasonable notice, so the seller can hop back on the property and look at stuff. If the seller needs to inspect the property for whatever reason, as a landlord, you're not a landlord, but as a person letting someone else occupy your property, you theoretically have a right to wander on and make sure that they're not setting fire to the couch or something like that. The buyer should permit the seller back onto the property at reasonable times and with that reasonable notice. So the buyer, if you're living in the property and the seller says, hey, I want to come and check out the property in a couple days, the buyer should go, yeah, how about 9 o'clock? I'll be home. That's fine. If the seller says, hey, buyer, I'm at your front door, open it now, that's not reasonable notice. If the seller says, hey, buyer, I want to check out your house, how does 1 a.m. sound? That's not a reasonable time. So, be reasonable human beings, please. And if the seller is asking the buyer for permission to enter onto the property to do repairs that the parties agreed to in the sales agreement, let's say during inspections while the buyer's living there, they say, wow, this roof is leaking. You got to fix that, seller. And the seller says, yeah, no problem. I'll get a roofer onto the property. I'll fix that roof. And during that time, when the seller's roofer shows up to fix the roof, the buyer goes, I live here. You can't come up onto this roof. When I was a kid, we had a neighbor that was very unreasonable with contractors and basically said the contractor couldn't do work while their child was asleep because it would ruin their nap time. If you're one of those buyers that's like, you can't do work on the roof because my child is sleeping and you'll infringe on their nap time, the seller doesn't have to do that repair anymore. That's essentially what we've set it up as. If the seller is not granted permission to enter the property and repaired the condition as was agreed to in the repair addendum, the buyer has waived their right to that repair. So buyers, if you're going to ask the seller to repair stuff, let them repair the stuff. Don't put arbitrary or capricious rulings on when or why the buyer or the seller is allowed to enter to fix those things. If you're asking them to replace the smoke detectors, you need to let them in to replace the smoke detectors. If you close the door and lock it and change the locks on the seller and they can't get in, the seller doesn't have to do that thing anymore. Now, theoretically, under federal law, they would still, or state law, they would still have to replace the smoke detectors. So it was a bad example. Let's say it was something like drywalling. If the seller is supposed to, scrape the popcorn ceiling off the walls or put some texture on the drywall and the buyer stops them from entering the property, seller doesn't have to do that thing anymore. The buyer has caused the problem. They have not granted permission to enter and to repair the property. There are a couple other provisions that are pretty relevant in this. For example, what happens if someone else is injured on the property? Buyer is solely liable for any injury that occurs to other people on the property resulting from the activities or taking place at the property, and if that damage occurs to the real or personal property of others as a result of buyer's use of the property. So buyer, you're liable for damage to people, to places, to things that happen as a result of your use of the property. Buyer is also indemnifying and holding harmless seller for as well as buyer and seller's agents and their firms and their employees and their transaction coordinators and all those other people and all the representatives of those firms. Everybody is indemnified by the buyer against all claims, suits, judgments, and reasonable attorney fees and all that other stuff will be paid by the buyer. The release of the real estate brokerages is also built into this. It's the final section of the form, which basically says buyer and seller agree, and they're indemnifying the agents. You are scriveners. You will write this thing for the parties, but once they're under lease or under the occupancy agreement, rather, you're not a part of it anymore. You're not negotiating lease terms. You're not helping the parties with property management. It's between the buyer and the seller once the occupancy starts up. You are excluded from this awkward kind of semi-ownership lease situation. When we talk about indemnity, sometimes this is a clause that people kind of are a little vague or fuzzy on. So this is a silly example that sometimes works. Let's say that buyer has a really dangerous dog that the buyer keeps in the garage during their occupancy. While the buyer is living on that property, they have a house guest come by, and that house guest, ill-advised, opens the garage door despite the little sign that says beware of dog. The dog attacks the house guest. That's unfortunate. The guest sues. They got injured. They got torn up by a dog. So what is the guest going to do? They're going to sue literally everyone they can find to pay for those medical bills. So they're going to sue the buyer. They're going to sue the seller. They're going to sue the agents. They're going to sue everybody because they want to get something out of this tragedy. So when the guest sells the seller and the buyer for that injury, because the buyer has indemnified the seller, buyer will be paying for the seller's damages if any occur. If the judge says, yes, seller, that was your house that this person got injured on, you owe this person $1,000. Buyer, you're paying for that cost, as well as the seller's attorney fees. That's how indemnity works. It basically says, buyer, if there are any costs, legal costs that happen due to your usage of the property, you will do all of the protections and the payments and the expenditures and all that other stuff for all the parties that you're indemnifying. That's what this provision does, is it basically makes sure that the seller is not out money by having a buyer living on the property if there is a lawsuit that happens as a result of buyer's failures to act or foolish actions. There is also an insurance provision. Sometimes insurance is really important. In these cases, it's quite important. Buyer, if you're living in the house, you should get a renter's insurance for the entirety of your term. They should have liability coverage of, and the party can set the amount. $1 million is a fair number. It can also be a significant amount more, or 500,000, whatever the parties feel comfortable with. You should also have the seller listed as either an additional named insured or an additional named interest. We had a whole conflict back and forth while drafting these forms with the insurance people about whether or not to use additional named insured or additional interest. Legally speaking, they're the same concept, but insurance people keep telling us they're different. I've never actually gotten a clean answer from the insurance people as to why they're different, other than just a company has decided to use a new word to create kind of new areas where they can create conflict. So you're going to do one or the other, where they're both accomplish the same thing at law. Buyer needs to provide that proof of insurance to the seller within a set number of days prior to the beginning of the occupancy term. So before buyer moves in, they need to prove to seller that they are insured. That's important because sometimes mistakes are costly. If the buyer's smoking in bed and they cause the house to burn down, you better hope you had enough money to deal with that. The party should also make sure that the seller should get a homeowner's policy and casualty insurance policy that covers the replacement value of the property, whatever it ends up being. That's the smoking in bed example. If the buyer burns the house down, seller, you want to be able to replace your property. And even though the buyer's insurance might cover some of it, you want to make sure that if it doesn't, you can still replace your property because it was your property. The party should also get any additional coverages that they want if they do want any. You can go above and beyond if you want. You don't have to. So get whatever policies you want. If you want to have some sort of a rental coverage, if you want to have flood insurance coverage, all those other things, if you need those because your lender says so, get those things. We didn't specify in this section. We just said kind of whatever else you need, go for it. Buyer and seller should cooperate with each other with respect to filing any insurance claims. They should cooperate with each other to repair after a casualty event. If the buyer, for whatever reason, causes the front patio to fall off the house, the buyer should really help with the filing of that insurance claim and cooperate with the seller's efforts to repair the property and put the patio back on. If there is a casualty event that occurs during the occupancy term, seller can just terminate the occupancy agreement after 48 hours notice to the buyer. So if the buyer, for whatever reason, decides to jump through a window, the seller can terminate the buyer at that point after 48 hours notice. The idea behind this is if the buyer is causing a casualty event, the seller may really want out of that transaction, or if they get out of the transaction, they don't want the buyer living there anymore because they're already causing damage. So you've got that additional kind of end right there as a seller. For utilities, the buyer is going to be paying for utilities on or to keep them on all the time. So utilities such as replacement cost of fuel and all that stuff during the occupancy term will be paid through the occupancy term by the buyer. This might mean that you have to transfer over utility bills. It might mean in some cases if the utility company says we won't transfer the bills until you own the property, you might have to do something crazy where the seller sends the bill to the buyer and then the buyer remits a check over to the seller that says, hey, for the $60 worth of electricity, here's what I'll pay. Most utility companies will allow you to move those across, but sometimes you get weird companies that do some odd things. The death of the parties provision is what amounts to the survivorship contract clause. This essentially says that if one of the parties dies, this is still binding on the successors and estates. This means if the seller dies, the buyer still gets the value of the agreement. Just because seller died doesn't mean buyer has to move out. The seller's estate takes over the property and technically is the owner of the property and is still working on that sale, but the buyer doesn't have to move out just because seller died. If the buyer dies, technically the buyer's heirs and successors can live in the property under the terms of the agreement. This usually is used to keep spouses and children on the property if they were living there, while the estate of the buyer figures out what they're going to do with the sale. If for whatever reason the estate says, yeah, we're not going to buy this house anymore, at that point that 15-day termination thing would begin, and at that point the heirs and assigns would be booted out based on 15 days, calendar days after the termination or end date of that occupancy agreement. There's also dispute resolution clause that says you're basically going to do this like the sales agreement says, take it to arbitration, take it to mediation, take it to small claims court, unless there's a failure to vacate. If there's a failure to vacate, straight to forcible eviction to FID, forcible eviction detainer lawsuit. That's what you would file in those failure to vacate contexts. Encumbrances, we did talk about a little bit earlier. That was those instances where the buyer is living on the property and they want to put a second mortgage on the house. Somehow they figure out they have some lender that does something risky and wants to put a second mortgage on it. The buyer, we doubled down on it and said, buyer, look, you can't put liens on the house. You can't grant the creation of a lien. You're not supposed to help somebody put a lien on it. You're not even supposed to permit the existence of a lien that's caused by your actions. So buyer, don't let there be liens on the property while you're living here. Once you own the house, go for it. But until then, don't do it without seller's permission. You're creating problems for the seller's title at that point. There's a non-waiver provision as well, which basically says that if the seller doesn't invoke one of their rights, that doesn't mean that they've waived that right forever. So if the example is like a seller says, "Hey buyer, we were going to have you." We had a separate general addendum that says buyer's going to pay every week. They'll pay $600 a week for living in my property. Week one rolls along, the buyer doesn't pay the $600, and the seller goes, "Okay, buyer, I'm going to give you another 3 days. Please give me that $600. Otherwise, we're going to have a problem." Buyer pays it. The next week rolls along and the buyer doesn't pay the $600 again. And the seller just says, "Look, you're out. You're done. You've breached the contract. We're done here." The buyer can't come back and say, "Well, you gave me 3 days last time, so I thought I'd get 3 days this time." Non-waiver means you don't, just because the seller did it one time doesn't mean they're going to do that same level of permission every time. Just because they've rejected some sort of an invocation of their right the first time doesn't mean they reject that invocation every time. Section 20 is the exchange of keys. This one is just a broad answer because it gets all kinds of weird stuff on this one. We just left an additional instructions section. Seller, you get the keys at the end of the buyer's occupancy term. Once the buyer's not living there anymore, keys go to the seller. You can put in additional instructions. This is for whatever you want. Put it in the safety deposit box, give it to the escrow company, put it under the garden gnome, whatever it ends up being, however you want to get the keys back to that seller, write it down. In absent any other instructions, the buyer will just deliver it as they see fit. So if you've got a seller that's really specific about how they want to get their keys, write some really specific stuff under this section, like put it under the garden gnome at 3 a.m. on the last day of the occupancy. I'll come rolling around and pick it up at around 6 p.m. that night. Like, you can do those things. You can be as specific as you want. Lastly, there's also the changes to the agreement section. So what happens for this if you want to change the agreement? You can modify the occupancy agreement, but those changes need to be in writing and both parties have to agree to any changes that occur. So if there are going to be any kind of a modification, put it in writing, both parties sign. If there are discussions, negotiations, or amendments to this occupancy agreement that happen after the occupancy term begins, these are the parties figuring that out. The buyer and seller's agents don't have to be a part of it. You can, but you don't have to be. So if the parties start living in the space and then the buyer and the seller they decide they want to do something sketchy, they say, well, I really like this buyer, so let's let him stay for another 70 days, and that takes you over the 90-day number, and then there becomes this whole giant rigmarole about the problem of a lease that didn't exist, and now it's an oral lease, and you need to give them 30 days notice to terminate, and that creates problems for the seller. The seller can't come back and say, broker, why didn't you tell me about these things? Because your obligations end when this occupancy agreement is created. You don't have any obligation to assist with all of the subsequent stuff the parties do to it. If they want to do something sketchy with modifying this occupancy agreement, they can do it. You can advise them, but you don't have to, because you're expressly excluded from everything after the start point of the occupancy agreement. Until closing, this is another right that's real important to be in there. This is just kind of an additional, is a boilerplate term. Until closing, seller is the legal owner of the property. Buyer has no rights related to the property other than those given by the occupancy agreement. Buyer gets to occupy and possess and enjoy it to a certain extent, use it for residential purposes. They don't own it. The seller still owns the property. They own title. They own they're on the name on the deed until closing, and that's just kind of expressly stated again. That's the whole agreement. And this was not as exciting as some of my other slideshows have been. This was really light on my little clip art images. So if there are questions or anything else that needs clarification, please ask those questions now. But that's what I've got for people at this point. Questions or comments? If no questions or comments, then that's what we've got today. So thank you all for attending the presentation on the training. Our goal is that we'll have the CE certificates sent out in 2 to 3 weeks. We usually shoot for 2 weeks, but some days we get busy, and so it's 3 weeks is kind of the long end of it. With your names on here, we should be able to get these to people. It should be no problem. So once our education folks get back, they'll start processing CE, and we'll get that out to you. So with that, everybody have a wonderful Friday. I'll stay on for another 5 minutes if people have questions, but otherwise, this video should be posted up on the website, orforms.org, at some point relatively soon, just so people can see what we're dealing with as well. I'll throw this onto orforms.org is the website where you can find this stuff. If you go up to training, you can look at live trainings and webinars or recorded tutorials. Recorded tutorials takes you to our YouTube playlist where we have all of our previous versions of these trainings. We update it as often as we can. So we've got our various trainings that we've done on a weekly level on these various purchase and sale agreements. We should update this a little more as time goes on. We haven't updated, I think, in a little while, so more of these videos should be forthcoming. So if you want to see this video and you want to slow it down so you don't have to listen to me talk at just an absolute chipmunk pace, that will be on the website, and you can use YouTube to put it at 0.5 speed, and my voice will be very understandable. Do I know terms on Airbnb? It's a good question. So if you have a property that is under an Airbnb, these occupancy agreements wouldn't necessarily apply. The reason why that's the case is Airbnb creates a separate contract between Airbnb, the company, and the homeowner, the seller. So if I was a buyer and the seller had the house on Airbnb and the buyer wants to buy the house, and then the buyer rents the property on Airbnb for like a really long time, that's an Airbnb contract. The occupancy agreement you wouldn't want one of those in place, because then you'd be essentially double leasing the space to the buyer as well as Airbnb leasing the space to the buyer. That's kind of what you want to avoid on that one, is it creates a double up that you don't want to be a part of. So for Airbnb, it's a special case. If you've got a property, a seller's property that is leased out on Airbnb like well into the future, and the seller is also selling that house, we've had that come up on the legal hotline. It's a problem. You're really not supposed to have Airbnb contracts ongoing while the property is being sold. If there's an occupancy agreement going on, if the buyer has signed the sales agreement with the express understanding, I will be living in the property, Airbnb contracts shouldn't be in place that infringe upon that ownership right that the buyer will have, the possession right. So if you've got a seller that's doing Airbnb and an occupancy agreement at the same time, one of those has to give. Either you don't do the occupancy or you clear out all your Airbnbs so that the occupancy can happen, but it should only be one at a time. Someone said they had a phone call and missed the beginning of the recording on the 90 thing. Take a minute to review again. Yeah, so Oregon Residential Landlord Tenant Act. Let's go way back in the presentation. The Oregon Residential Landlord Tenant Act applies only if you have a lease that goes for more than 90 days or an occupancy that is more than 90 days. This applies for both 90 days, 90-day occupancy of the dwelling by a purchaser prior to the closing date or by the seller following the closing date. But what that essentially means is from the closing date, there's a 90-day window in both directions where even though you're occupying the house and it's a residency and you're technically a tenant, the Oregon Residential Landlord Tenant Act doesn't apply, which means if you have to terminate a lease, you don't use the traditional termination standards if you're under that 90-day number. So you don't have to do the 30-day notice. You don't have to do the fixed term, wait until the end of the fixed term to give notice, sort of thing. The lease basically plays by none of the same rules as a normal lease. That's what the 90-day thing is. So if anyone wants to take it beyond 90 days, well, now you're under the Oregon Residential Landlord Tenant Act, which means you've got relocation assistance. You've got potentially those like COVID give somebody warning statements and ask for, did you ask for rental assistance? And if you said yes, then I'm stymied from being able to terminate the lease for X number of days until I get a statement from the department. All those things don't apply unless you've lived there for 90 days or more than 90 days. So that's the answer on the 90-day thing. How prevalent are buyer occupancies before closing? Seller occupancy past closing is common. Your principal broker strongly discourages against buyer occupancy prior to closing. Risk mitigation comment. I would say buyer close occupancy pre-closing is irregular. It's not common, but it does happen. It's more common when you've got someone moving across the country and their timelines are really kind of stymied by things. It's also more common when a party doesn't want to make a deal contingent. So if you have a seller that says, I want to sell this house to you, buyer, and the buyer says, well, that's great, but can we move the timeline up because my house is closing in 30 days and I'll sell my house in 30 days, and the seller says, nope, it's got to take 90 from me. At that point, the buyer's house sells in 30 days, and if the buyer really wants this house, they just need to rent somewhere for 60 days. In those cases, sometimes the buyer will say, well, okay, can I live in your house until I buy it? Because I want to buy it, but I also will have sold my house by that point. Those are the cases where you do have these occupancy agreements pop up. On a risk management level, your principal broker is absolutely correct. In general, as far as risk management goes, any level of occupancy agreement is a bad move for risk. It is inherently risky, it's inherently problematic, and leases are a funky place. The reason why it's inherently risky is at all times your seller is basically saying, I trust the buyer, or the buyer is saying, I trust the seller with my property, which is not necessarily wrong. It's okay to trust people, but that means you are farming risk out to a place that you don't normally have to. So from a risk management perspective, never do these. From a practical standpoint, these happen. And if they do happen, the best way to mitigate your risk is to have an occupancy agreement in place that says, here are the terms of engagement. Here are the rules we're going to follow. If any of these rules are violated, here are the ways we can respond. We're going to make sure everything follows exactly as we plan it to. So having these agreements in place is how you mitigate the risk. The best way to mitigate risk, though, is never to do this in the first place. It's one of those like, what's the best way to avoid a fight? To never get in a fight. It's as easy as that. Any other questions? These are great questions as well. Thank you everyone for spending the time. We truly appreciate all the time, the interest, and we really hope that brokers in the state of Oregon are going to get really comfortable and familiar with all these legal concepts and all these forms questions, and that there comes a point where these trainings will be as silly and nonsensical as all of the other trainings that people never want to do. So our hope is everyone learns this stuff just perfectly, and we never have to worry about it, and it'll always be a lovely thing where no one gets in any legal problems ever. Already taking you guys 2 minutes past, so thank you everyone. We're going to end the webinar. We appreciate all of you, and everybody have an excellent Friday and a good weekend, and stay cool out there. It's supposed to be in the 90s for at least the Willamette Valley area. And